People often wonder whether it matters who files for divorce first. And the easy answer is no. But that's not the entire answer. The answer is, yeah, it can. Once upon a time, race to the courthouse used to be more important than it is today. So in other words, one party getting in before the other, particularly if one party has moved and run away and they want to get jurisdiction somewhere else. These things don't matter so much anymore. The law is much clearer as to what court is going to hear the case. And the whole incentive behind race to the courthouse has changed. However, there are times when it can be advantageous to be the first filer, and there are times when it can be advantageous to not be the first filer. And more, there's actually times where it's advantageous to file together, even if you are not uncontested, if you still are a contested divorce, but you're joint petitioners. The easiest one is that the person who files first pays a higher filing fee. So the court filing fee is double for the first filer than for the responder. So there's that. And we're not talking about tons and tons of money, but a couple $100 of difference. And when you joint file, then you share the initial filing, and nobody has to be a responder or respondent in the law. So that's a small thing, but a lot of people consider that to be something worth considering as they decide who's going to file first. What are some other things? Well, if you file first, you control the timing of when the mandatory injunction will fall. Now, if that's unfamiliar to you, when a divorce is served on another party in Colorado, so it's been filed and it gets served, there is now a mandatory injunction against both sides that says you must maintain status quo. You can't sell marital assets, you can't purchase marital assets, you have to operate the marital estate in a manner consistent with the way that it was operated before the filing of the divorce. Knowing when that's going to happen can be very advantageous because the party who's thinking about divorce might choose to take some actions that might not be allowed once the mandatory injunction has fallen into place. Now, if this was shown to be done in a unfair way or in a fraudulent way, these things can now hurt you later down the road in the distribution of assets. But in some ways, it's just good to get your ducks in a row before the mandatory injunction falls into place. And so having control and knowledge of when that's going to be can be advantageous and be a reason to be a first filer in a divorce and not be a respondent. Because as a respondent, once you've been served, boom, mandatory injunction's in place, and you're stuck in that particular situation. Other than that, there's no particular advantage these days to being the person to file first, and there can be some disadvantages. Venue needs to be in the place of the person who's the respondent. So if you don't want to go to their county to defend your divorce, you might want to be the second filer so that the divorce comes to you. That's one of the few circumstances where it would be advantageous to be second. But most of the time, it just simply doesn't matter anymore. What does it take to file a divorce in Colorado? It's actually not a complicated process. And more we find that clients who work with us have already filed. We don't recommend this because, again, you have potentially changed the timing of the case and or said things in the filings that we might not have wanted to say or said them in a way we might not have wanted to say. But the process itself is very simple. There are forms provided that the court can give you that you can fill out by hand, bring to the clerk of court, and pay your filing fee, and it's filed. And then you're responsible for serving it on your spouse if it wasn't filed as a joint petition. And they will show you at the court how to have that given to a process server or the sheriff to serve on your spouse. Now, when you have your law firm do this, the law firm goes through some of the same steps, except they won't necessarily use the form from the court and will say things and put things in such a way that will be most advantageous to you in beginning the divorce process. Also, the law firm might seek to have your spouse accept service, so that they don't have to have a sheriff or a process server come drop papers at their workplace or at their home, and may also seek to have them join as co-petitioners. There's a lot of different strategies that a law firm can use to make the filing process better for you and better for the prospect of resolving the divorce or whatever other matter you're prosecuting in a more amicable manner. So can you do it yourself? Absolutely. It's actually a very simple process. Is it the best idea? Usually not. People throw around the term no-fault divorce. What does that mean? Many states, like Colorado, have entered into a no-fault divorce regime. So in other words, once upon a time, you had to state grounds for your divorce. You could state abandonment, infidelity, cruelty, and one of them, on the way to no-fault divorce, the term irreconcilable differences got added to the list. And in fact, I think there's been a movie about this, irreconcilable differences. But you had to prove that too. And so part of the divorce process was that you had to prove one of these aspects to show that the divorce could be entered. And so that in the divorce process, the other side could actually dispute this and say, no, there was no cruelty. No, there was no infidelity. No, there was no abandonment. And so there should not be a divorce. And they would even sometimes dispute irreconcilable differences. It kind of seems funny to go to court to fight about the fact that there are not irreconcilable differences, but this has happened. More recently, states like Colorado have moved to no-fault divorce, which means you no longer have to state grounds. They are no longer relevant. A divorce can happen when one party no longer wants to be married, and they file for divorce, and divorce will be entered if the court doesn't find some problem with that filing, like fraud or duress or something like that. But so you don't have to have a reason. Because of this also, though, a lot of the aspects of the divorce that used to be important, like if you were charging abandonment, you were charging infidelity, you were charging cruelty, and you won, then these would be reasons to grant more support to you, more marital support, kind of like damages in a civil suit. Like they would, as punishment to the other side for having caused the divorce by doing this bad behavior. Well, since divorces are now no fault and you don't need to, or a lot of times courts won't even let you prove bad behavior, then the awards of damages for that bad behavior also no longer exist. And so the distribution of assets is done equitably. The award of marital support is done on an equitable basis based on need and based on disparity in income. Child support is based on a formula. And so these things are no longer considered, the faults that used to be considered are no longer considered and are no longer necessary in prosecuting a divorce. If you've decided that divorce is what needs to happen in your marriage, whether or not the other side agrees, it's now time to prepare. Most people have actually not done the preparation necessary even to have gotten to that point. I'm not going to question in this video whether that decision was the right decision or the wrong decision. That's not for me to do. But what I will suggest is that I want to be sure that in making that decision, you have done the work to understand what the future is that you want. So in preparing for the divorce, presuming the decision was the right one, we need to consider that future. We need to continue the work to have a very clear picture of what the future is that you are moving towards. Where do you want to live? How do you want to live? Who do you want to live with? Which can include nobody. And then all the details around the answers to those questions should be crystal clear in your mind. And if they're not, it pays to work with a therapist, a divorce coach, or a law firm that will walk you through those questions and not rush you to filing for divorce. because until you have clarity as to those questions, you're not ready. And when I say you're not ready, I mean you're not ready to prosecute the divorce, to move forward through the divorce in a way that moves you towards that goal. If that goal is not crystal clear in your mind, the divorce process can hurt you more. And we don't want that to happen. We want the divorce process to move you towards the future that you want. So to answer the question of what you need to do to prepare for a divorce, a lot of lawyers will give you answers about what you should do to move money, to secure money in a separate account, to register the children in a different school, to move assets, to prepare to move out of the house, or prepare to have the other person move out of the house, and all these other tactics. Those might be good tactics, or they might be terrible tactics, depending on your goals for the future. So the first thing you need to do before you consider any of those other preparatory steps, and it would be foolhardy for me to make a video for you describing which of those you should do, whether you should move money out of the bank accounts, not move money out of the bank accounts. I don't know anything about your particular situation right now except one thing, that you've got a future and you can be in charge of it. And that is the number one preparation you should do so that you can empower yourself to make the best decisions for yourself and your family.